Hey, my name's Greg. I'm an attorney. I used to do debt collections for debt collectors. Now I've changed paths. I'm here to help you learn how to beat your debt collector in court. Now, there's a lot of resources out there on the internet that tell you what to do when you get sued with a debt collection summons. They give good advice. They say you should file an answer to the summons, send them a debt verification letter. Those are both really good ideas and really good advice. The problem is nobody ever tells you what you do next in order to beat your debt collector once you get to court. So I'm going to give you a tip today that's going to help you win your debt collection case. And that is you need to file what's called initial disclosures. Now, initial disclosures is a list of two things. It's a list of the witnesses that you need to present at a trial to make your case that you don't owe the debt. And it's going to be a list of the documents and other items that you would need in order to present them to the judge to convince the judge that you should not pay the debt. Now, you do this by first thinking about who are your witnesses going to be. In a debt collection case where you're defending yourself, primarily that's going to be you. You're just going to list yourself along with your contact information. Maybe you have a friend or a family member that helps you pay your bills or was there when the service happened. Maybe it was a medical bill and you had a family member that was there with you when the service was rendered and it wasn't rendered correctly, something like that. Maybe you want to list that friend or family member. Make sure you put their name, their phone number, and their address on that initial disclosure form. Then you want to list the documents that you need to make a case. This is going to be things like receipts showing you've already paid the debt. It's going to be the original contract. It's going to be some document or a picture showing that the service that you purchased wasn't rendered the way it should have been so that you don't owe the money that they're claiming that you owe. Something like that. Really, any document, picture, any item at all that you need to make your case that you don't owe the debt, you need to list it in your initial disclosures. What you do next is you take that list of items and you include a copy of all the documents that are listed there. You make a couple copies. You make one for yourself, you make one to send to the other side, and depending on your state's court's rules, you may need to file a copy with the court as well. You want to send those documents all to the other side. That's going to tell them this is the evidence that we have to show that we don't owe the debt. Now, how's that going to help you win the case? Well, what this tells the other side is that you are willing to fight and take this case all the way. Attorneys that file debt collection lawsuits, they don't like it when you fight the case. They're looking for quick hits because they only get paid when they collect on a debt, and they have to take so many of these cases to be profitable that they really need to churn through them quickly. So what they're going to do is see you and that you're fighting the case. There's a pretty good chance that they might just drop the case. It's not going to be worth their time or effort to take this case all the way through trial when you've shown that you're willing to do that. Now, maybe you don't get lucky. Maybe they're not willing to drop the case altogether, but they are most likely going to be willing to enter into settlement negotiations because they know that you are serious about fighting the debt. And it's going to be more cost effective for them to reach a settlement agreement with you for less than the amount of the debt owed than it is for them to spend all the time, money, effort in preparing for and going to trial. So when you serve your initial disclosures, you need to be in contact with them. What kind of deal can be reached? Will you take, pennies on the dollar to settle this debt? Now, if you're lucky, you're going to serve your initial disclosures and you're going to have a lazy attorney on the other side that is not going to serve their initial disclosures. What you want to do in that case, you want to hit them with a motion for summary judgment. Basically, that tells the court, hey, the other side didn't give me any witnesses, didn't give me any documents, so they cannot make a case at trial, which means the court has to grant summary judgment in your favor. That means you win, you don't owe anything. There is no debt anymore. So that's the best way to make sure that you beat your debt collector in court. I see this mistake all the time. There's always people that will file a response to the summons. They'll file an answer, but they don't do anything else. They don't serve any initial disclosures. And the next thing you know, they get hit with a motion for summary judgment. They get contacted by the court that says, you got to be here, show up on this date at this time. And the judge says, hey, I'm finding summary judgment in favor of the creditor. You owe the full amount plus attorney's fees, plus costs, plus interest. And these debtors, they don't know what hit them because they don't do this one simple tip. You need to be serving your initial disclosures after you file your answer when you're sued for a debt. If you don't know how to make these forms, that's all right. We've got you covered. Head over to www.debtbrief.com. We've got forms for sale. It's going to give you all the forms that you need to beat your debt collector in court, along with an ebook that you can use as a guide. We've also got a ton of other blog posts, tips, tricks, videos, whatever you need in order to beat your debt collector in court. So that's our mission at Debt Brief. We're here to help you equalize the playing field. They've got attorneys on the other side. I know how they work, and I'm going to teach you how to beat your debt collector in court.